was admitted question. Whether the learned court below carrying this misinterpreting the documentary evidences produced by the parties. Whether the findings of the learned court below mean unregistered SADA agreement A is legal and factually sustainable. Question number 4 was whether the learned court below committed serious error of law in recognizing the unregistered SADA agreement A as symptom of partisan defected between the parties. And 5. Whether the finding of the learned court below were justified in holding partisan taken place between the parties on the basis of recording of possession in remark column in the record of rights. Whether the finding of the learned court below against the reading of the parties can be sustained. And the last one was whether the finding of the learned court of appeal below is violated due to taking irrelevant documents in consideration. The purpose of the जजमेंट में इशू फ्रेम था उसमें 3 and 4 क्वेश्चन नंबर 3 and 4 were given in paragraph number 9.
You just come to the issues framed by the learned trial court. Para number 4.
4 and 5.
Para 4 of the trial court.
Yesterday I don't have example of trial court.
You have the appellate court judgment?
Yeah.
You come to that. You read para 14.
The other hand I have told.
Para 12. Para 12.
Having heard the argument of parties and perused the evidences available on the record, it appears that both parties have adduced oral as well as documentary evidences in support of their respective claims. First of all, I would like to analyze the document produced on behalf of both the parties. Exhibit 1 series is Khatnan of Khata number 74 and 75. The land abandoning Khata number 75 belongs to Devu Mandi, Ganesh Mandi, Chandu Mandi, Jarva Mandi, Budwa Mandi, and Tapia Mandi, who are ancestors of both the parties. While Khata number 75 belongs to Khata number 75 belongs to only Devu Mandi, Ganesh Mandi, and Chandu Mandi. These documents are admitted documents and there is no dispute regarding the same. But इसमें दोनों 75 बोल रहे हैं खाता नंबर 75 belongs to.
No, you'll find it from here only. In the trial court statement it has been mentioned. The khata number 75 is shown in the name of Sukar Mali alone. It's not in the name of others. Supramani.
Record of rights was in the name of Supramani. Supramani दो हैं, एक उनके बेटे भी हैं
And वो भी है.
father.
Yes. दोनों का सेम नाम.
और जो ट्रांसफर किए हुआ सुब्रमण्य उनके बेटे हैं लक्ष्य कॉल बिफोर his death ट्रांसफर हुआ है then he was issueless.
See, there is nothing in your case. Both the courts have given concurrent findings. Second appeal number 478 of 2018. Heard the Land Council appealing on behalf of the appellant and we have of the applicant. Your name?
Sarveshwari Kumari.
Ms. Sarveshwari Kumari. This appeal has been filed. Against the judgment dated 21/8/2018 within bracket degree dated decree signed on 13 date is not valid. Decree signed on 31/8/2018. Bracket close passed by learned additional judicial commissioner Roman 6. 21st August 2018. Following the judgment and decree dated 6/9/2018 within bracket decree signed on 18/9/2017 passed by the learned registrar Municip Roman 13 Ranchi in partition suit number 161 of 2009. The learned counsel for the applicant has submitted that the suit was filed for partition of the suit property. But the trial court dismissed the suit. The appellate court dismissed the appeal, and consequently the plaintiffs are the appellant before this court. The learned counsel submits that the judgment passed by the learned courts is perverse, and she submits that a substantial question of law will be framed and the appeal will be decided. The learned counsel submits that the learned courts have not appreciated the materials on record properly. This court finds that the suit was filed for a preliminary decree, a partition of the suit property, giving half share to the plaintiff, and for a further relief that the permission granted in miscellaneous case number 611 R8 Roman 2 of 2007 dated 4/1/2008 by the Deputy Collector Ranchi be declared void ab initio, ineffective and fraudulent, and for the further declaration that the same deed bearing number 750 dated 17th of January 2008 executed by Sukar Mahali defendant number 1 to defendant number 6 Sukra Oraon is void ab initio, fraudulent, illegal, inoperative and ineffective and not binding on the plaintiff and the defendant number 2 to 5. The case of the plaintiff was that khata number 74 and 75 was recorded in the name of ancestor of the plaintiffs and defendant number 1 to 5. and khata number 74 was recorded in the name of BT, Ganesh, Chamra, son of Sukra Mahali, and Charva Budva and Dipya Mahali, son of Radhe Mahali, whereas khata number 75 was recorded in the name of Biku, Ganesh, and Chamra Mahali, son of Sukra Mahali, in RS Record of Rights. It was therefore the case that that the land of khata number 74 and 75 were in joint possession of the plaintiff and the defendant number 1 to 5. And the same was not divided, but for convenience they were cultivating the suit property separately. The plaintiff alleged that Sukra Mahali, son of Chamru Mahali, who was defendant number 1, had without the consent and approval of the plaintiff and defendant number 2 to 5 sold 30 decimal of plot number 553, khata number 75 by way of absolute sale by DT.13.01.2026 to defendant number 6, Sukra Uram, and the permission of the concerned authority for the sale was obtained fraudulently. It was alleged that the defendant number 1 had acted in collusion with defendant number 6 and committed fraud upon the plaintiffs as well as the defendant number 25. Internal page 2 of the trial court judgment. Defendant number 1 to 5 had appeared in 5 written statement and supported the case of the plaintiff. On the other hand, the defendant number 6 had contested the suit and stated that the defendant number 1 had amicably partitioned the suit land and the defendant number 1 had been in possession of the property, and consequently the defendant number 1 sold the property to defendant number 6 by registered sale deed dated 17/1/2008 by taking consideration amount of ₹75,000 and after due permission from the concerned authority. It was asserted that the defendant number 2 to 5 were well aware about the permission case and the sale deed was valid and the question of cancellation of sale deed did not arise. The learned trial court framed the following issues for consideration. Both the parties led oral and documentary evidences. The learned trial court considered issue number 3 and 4 together and recorded finding in paragraph 14 of the trial court's judgment that the property was already partitioned between Sukkar Mahali and Radhiya Mahali before preparation of the Khatyan, and the name of sons of both Sukkar Mahali and Radhiya Mahali was given in the Khatyan of Khata number 74, but they were in separate possession as per the remarks column of the Khatyan. It was also clear from Khatyan of Khata number 75 that the sons of Radhiya Mahali had no share in the Khata number 75, where the separate possession of two groups, that is the son of Sukkar Mahali in one group and son of Radhiya Mahali in another group, was shown in the Khatyan itself, published way back in the year 1935. And this fact was also admitted by the plaintiffs in the plaint, that they were in separate possession as per convenience, and after lapse of 73 years, when a portion of the land was sold by son of one of the recorded tenant, the suit was filed seeking partition and challenging the suit, challenging the same. The finding was ultimately recorded in paragraph number 15 of the learned Tribunal's judgment. The issue number 5 and 6 was also decided by paragraph number 16, but from paragraph 16 onwards. And it was observed that the factum of partition was already admitted by defendant number 2 to 5 in Exhibit E. And ultimately the court held that Exhibit 3 was a lawful transaction and was fully acted upon. The learned first appellate court has also considered the materials on record and has come to concurrent finding and held that after due partition, defendant number 1 had sold his share to defendant number 6. This court finds that both the learned courts have considered the materials on record and arrived at concurrent findings. The learned counsel for the appellant has failed to indicate any perversity in the matter of appreciation of evidence by the learned courts. There have been concurrent findings recorded by both the courts, and no perversity as such has been pointed out by the learned counsel for the appellant in the matter of appreciation of evidence. This court finds no merit in this appeal, which is hereby dismissed.
From deadly for getting an order 41 to 11, 1827, second appeal 262 of 2008.
we would like to see, we are sort of passed by this one, you recollect that on this visa of the second 16th December 2020,
Yes.
number of person they are 2 we have 5 CMP that has not yet been registered but filing number has been given. This is the receipt also 15277/25, stating all the facts which has been pointed out that during the pendency of CMP, the petitioner, sole petitioner died. Now, thereafter, the case was listed under the heading for orders, and 4 cases were also listed under the heading for orders. So that is my personal knowledge. And the order was passed. Subsequently, we saw that it has been restored. And thereafter, the second appeal. So therefore, I have made a prayer for recalling the order of restoration and for with the
So
prayer
that is pending.
that is still pending. That is the
It
filing.
will be listed before which court?
Because now that one number code is not available. So it may be earmarked to any.
You have to mention it before the Honorable Justice.
That is after removal of the defect. Because it has been registered on 22nd December 2025. Immediately after the order passed.
Essay
So
number
you will see the direct
2008.
listing of this appeal after
Essay number 262 of 2008. The learned counsel for the appellant has submitted that CMP number that a petition
Filing
has
number.
been filed. A petition has been filed for
modification of the
for
recall.
modification / recall of order passed in CMP number 222 of 2018,
15th March 2024.
dated 15/3/2024. He submits that this case may be listed after the disposal of the CMP number,
CMP filing number
CMP filing number
152
152
77
15277
of 2025.
of 2025,
Filed on 22nd December 25.
filed on 22nd December 20.
2000.
Both slipped in. He submits that the appellant is taking steps for removal of defects in the said CMP.
Yes.
ये नंबर देखिए 15277 of 25, dated 22/12/25. ये फाइलिंग नंबर है CMP का. इसको वापस करें. इसको वापस कर दें. Post this case on 20th of March.
Item 38, second to 145 of 2017.
Yes.
It's arising of reversal condition. So trial court, the suit was instituted by the plaintiff respondent hearing for declaration for setting aside one order dated 30th July 2003 with a further declaration that Vishwanath Singh and Radhe Singh are one and same person. The short fact I will just illustrate for the question that one Vishwanath Singh passed away and his wife
Where is the trial court judge?
it starts with quickly I will just give bird's eye view then I will come to that. So one Vishwanath Singh dies and his wife comes for an employment. That she makes a representation. Her representation was not decided, followed by an application before the CAT, that is original application 71 of 2003, that their direction was given to the railway authority to pass an order on the representation. The claim was rejected precisely on the ground that Vishwanath Singh had impersonated one Radhe Singh. Sorry, Radhe Singh had impersonated himself to be the Vishwanath Singh. So, and this lady is having a wife of Radhe Singh. So C cannot have a claim. Now, whatever be the case, now since CAT again application was filed for the CAT, and matter was said that we approved before because now this is a case of impersonation, so civil court of competitive jurisdiction. That is the cause of action how this suit has been filed. The trial court has written it. If you know, I will just come to the judgment. I will come to the trial court judgment. It's a so this is the background of the case. Now
So
issue.
you had the order dated 37/2003 was passed by you,
Yes, yes.
and they had challenged that order in the suit by saying that Vishwanath Prasad Singh and Radhe Prasad Singh are one and the same.
One and same. So now this issue, if your addition will come to internal page 6 of the trial court judgment. The issue, and this is the thing pointed issue, number F.
F.
Whether Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person.
Okay.
So now this issue, after all considering all evidences, if you are at internal page 9, your addition will kindly come. 9. Yes. Rather from page 8, bottom to 9, one paragraph evidence.
Yes.
In course of her cross-examination, this is plaintiff's cross-examination, the court is referring. She admitted in paragraph 31 that on 2/10/2000, one Dinanath Singh submitted a family list of late Babulal Singh, who had 4 sons, namely Radha Singh, Vishwanath Singh, Dina Singh, and Srinath Singh. So I just take a pause minute. So 4 sons of Babulal, his 1 son files an affidavit that is being highlighted in this judgment. That is Dinanath has filed, disclosing, and the 2 persons which we say that are different persons, Vishwanath and Radha Singh, are 2 different persons. Plaintiff's case is that they are one and same person. So with this fact will come, who had 4 sons, namely Radha Singh, Vishwanath Singh, Dinanath Singh, and Srinath Singh. So the plaintiff herself admitted that Radha Singh and Vishwanath Singh were 2 different persons. The plaintiff's side did not produce any family list and khatiyan of her native place, that is Rohtas, Bihar, in support of her claim. Moreover, exchange deed exhibit 7 shows that first name as Radha Prasad Singh as Vishwa Prasad Singh. So inference may be drawn that deceased employee was having first name Radha Prasad Singh. It is so also pertinent to note that PAN card, voter list and other documents were prepared from the address Gomo, not of Rohtas. No any documents of the deceased native house has been submitted by the plaintiff. Moreover, affidavit shown before notary cannot be treated as evidence under section 3 of the evidence. Now, PW2, who happens to be the Manoj Kumar Singh, he filed a complaint before the railway authority, saying that Vishwanath Radhe Singh has impersonated. He makes a complaint, so his evidence is now being discussed here. PW2 is a person on whose application Union Railway Authority conducted inquiry and case of impersonation was disclosed. Now he is deposing, now he comes in support of plaintiff. Now he is deposing on behalf of plaintiff. He deposed that his father's name was Buddha Singh and his father were 4 brothers, namely Vishwanath Singh alias Radha Prasad Singh, Srinath Singh, Dinanath Singh and Buddhanath Singh. Vishwanath Singh died leaving behind his wife Basmati Devi and son Madan Lal Singh. He further deposed that his uncle Dinanath Singh had land dispute with plaintiff and for that reason he filed a complaint bearing his signature before the railway authority. He also intimated this fact to the railway authority through affidavit on 1614. In the course of cross-examination, he admitted in paragraph 13 that railway authority conducted inquiry on his complaint, but it does not know about the result of the inquiry. This witness is not seen to be reliable and trustworthy witness, and it seems that he has admitted the claim of the plaintiff with ulterior motive. So he sets up with a different claim on affidavit before the authority. Now by deposing before the court, he comes with a different case. Now this is what is, now straight away your attention may kindly come to the appellate court judgment. Finding part, finding part, para 11, page 11, para 11. After discussing whole lot of evidences, para 11 on perusal of record. Readership is that page 11, para 11. Internal page 11. Mid part, readership will find para 11. On perusal of the record, I find an affidavit dated 2/11/4 sworn by Dinanath Singh before executing magistrate Dairy also, Rohtas, which is Exhibit 5, has been filed on behalf of the plaintiff. He shows in para 4 that welfare inspector took his signature on the white paper without his consent. Thus, inference may be drawn that railway conducted the inquiry through its welfare inspector and also went to plaintiff's native place at Azad so Bihar, and after the inquiry submitted to it is also found that Dinanath Singh is still living. One of the son is still alive, Dinanath Singh, and his affidavit before executive magistrate is of no value and same cannot be treated as evidence under Section 3 of Evidence Act until and unless he comes before the court and adduces and is subjected himself for cross-examination. From perusal of record, I also find that no voter.
Why would the plaintiff file this document? Because this particular affidavit is against the plaintiff only. Because this affidavit or what this document says that he had 4 sons.
Yes.
We are just
In
marked.
cross-examination, he admits. The plaintiff admits. On reference, page 8, bottom, 2 lines, the plaintiff is accepting this fact that one affidavit was there.
Yes.
And she admits that he has filed, one of the son files an affidavit saying that there are 4 sons. It is not the plaintiff, Dinanath Singh, who happens to be the brother-in-law of this plaintiff, husband's brother.
Okay.
So that in cross-examination, she has literally accepted the fact that he has made this application, and she has failed to bring anything on record. That is what is being discussed, Your Worship. That no native place, any document has been furnished. He lives in Rohtas, Delhi also, and he has produced some document of Gumu. So this aspect has been done, and finally finding is returned that there are 2 different persons, and it is a case of
Right.
impossible.
So you want to say that this is the cross-examination of the plaintiff?
Plaintiff herself.
So she had admitted that these 2 persons are different persons.
Yes, that is
in
what
this
this
cross-examination,
in cross-examination.
which became the reason for which was one of the reasons
One
for
of the
dismissal.
fundamental reasons for dismissal of this.
What happened before the learned applicant?
Yes, that is important, and that will be my substance that beloved appellate court has not dealt with any of this finding and has returned an independent finding as per 22. Yes, para 14, if you read until on page 6.
Yes, para 15.
40. The point of determination that same very whether Vishwanath Prasad Singh or Radha Prasad Singh are one and the same person.
Yes.
That is issue F. Now we consider 2 documents, I would say, and that is the document, one document. One thing, this fact has come that Vishwanath Singh died in the year 1984. This may be taken in the para 22.
You read para 15.
Para 15. On this point, PW1 Basmati Devi, the original plaintiff and the wife of the deceased late Vishwanath Prasad Singh, has reported that her husband, late Vishwanath Prasad Singh, joined Eastern Railway so 64 November, and ultimately on Itana while in service, so 2000, while in service he died, and since then she has not received any retirement pension, etc. Even giving several applications for also decided that rejected her application in 37/2003 on the ground that Radha Prasad Singh had joined the service in place of Vishwanath Prasad Singh, which is out and out wrong, whereas Vishwanath Prasad Singh and Radha Prasad Singh were one and same person. The defendant number 4 says that the fingerprint expert of railway on verification of late Vishwanath Prasad Singh in service record in LTI Panchanama was found to be of Radha Prasad Singh. She has further deposed that on 23/10/2000, Manoj Kumar had given an application before the railway that she was the son of Vishwanath Prasad Singh, and so he was entitled to service, etc. in case of him, and subsequently the same Manoj Kumar had further given an application that in his previous application dated 23/10/2000, was based on a wrong entry of the name of his father as Vishwanath Prasad Singh in voter list, whereas the fact is that he was the son of Buddhanath Singh and his father had never worked in railway, and further stated that Vishwanath Prasad Singh and Radha Prasad Singh were one and same person, and Basmati Devi being his wife and Madan Lal being his son are his heirs. Not only this, Deolava Kuer, the mother of Manoj Kumar, has also given an affidavit on 6/2/2004 regarding the same fact. She has further deposed that the registered sale deed dated 25/10/91 also proves that Radha Prasad Singh and Vishwanath Prasad Singh are one and same person. The witness has also proved several documents. In para 25 of her cross-examination, also she has admitted that the registered deed is the proof that her husband had two names as Vishwanath Prasad Singh and Radha Prasad Singh. PW2 Manoj Kumar has also deposed in paragraph 3 of his examination in chief that Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. He has further deposed that his uncle Dinanath Singh was on inimical terms with Basmati Devi due to land dispute. Therefore, he had given application to railway officer and the signature of this witness, in which the father's name of this witness was mentioned as Vishwanath Prasad Singh, who worked till 83-84, but the same was wrong. His father's name was Buddhanath Singh and he never worked in railway. In cross-examination, he has admitted that he had given application before the railway against the plaintiff. PW3 Shiv Shankar Ram and Kedar Singh have deposed that the plaintiff is the wife of Vishwanath Prasad Singh, alias Radha Prasad Singh, and Madan Lal Singh is his son. Manoj Kumar was the son of Buddhanath Singh and he was not the son of Vishwanath Prasad Singh. They have further deposed that Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. PW5 Madan Lal is so and so. He has deposed that his father was working in railway, was known as Vishwanath Prasad Singh, and he is Radha Prasad Singh. This witness has proved several documents. PW7 so and so. PW has proved various documents. Thus, on basis of the oral evidence of Basmati Devi, Manoj Kumar, so and so, it is clear that Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. Now, regard Exhibit 7, Exhibit 5A and 5B are directly related to the above. Out of this, Exhibit 7 is important document.
What is the date of Exhibit 7?
It is 1991, 25 to 91.
25/10/90.
91. It is a document related
Deed of exchange.
deed of exchange internally between the parties that refers Vishwanath Prasad Singh.
So there is an alias name in this document.
Yes, but now the thing is that the case that has been settled that Vishwanath died in 1984 and Radhe died 2000. Thereafter, this claim started coming up that there are two, 1 and 2. Because Vishwanath died in 84, thereafter this deed of exchange, the document which is dated thereafter, this fact has come 84. Now they have tried to say that they are one and same person. Now my submission would be that the trial court had discussed. Now under order 4131, the court would have displayed that fact. The finding, the cross-examination, the appellate court has not dealt with that.
This particular document of the learned trial, which has been discussed by the learned trial court,
Yes.
which you have said that he admitted, right?
No, this is not the document that he has admitted. This is one that is Exhibit 5 that is being said for.
This is Exhibit 5, 2/10/2000.
2000.
Right.
That is Exhibit.
She is just admitting that one Dinanath Singh had submitted the payment.
For which now they have set up in oral evidence that they are in inimical terms, so he may have said. So my submission is the 4111 valid in this reversal. The trial court, the appellate court has not dealt with the issue finding reasons assigned, as your leadership has held in one of the judgment passed by your leadership, that 4131 content mandates that you give a differing opinion or finding, then it has to be specific reason has to be assigned why the trial court judgment is not to be. Nothing has been said for this. And para 26, if you judicially find, straight away the finding has to be returned based on that exhibit 7. Now, exhibit 7 is an internal, maybe it is a registered document.
So you just tell me
Yes.
that which particular finding recorded by the learned trial court and which particular evidence recorded by the learned, considered by the learned trial court has not been considered by the learned applicant.
Number one, that this Manoj Kumar's evidence, that is para 20, which is referring that.
Manoj Kumar's evidence, can you refer to that in the trial court statement? Where is that?
Yes, it has been dealt with.
Yes.
I'm just missing.
Which paragraph?
I'm just. It is page number 9, internal page 9, middle part, PW2.
That's right.
It has been dealt with, and it is said that he is not trustworthy because he made an application on a affidavit before the railway authority that they are two different persons,
That's right.
and then he comes before the court and says that I mistakenly I had given under impression, but they are the one persons. Now, appellate court, while deciding this issue, has simply said
Has
that
not considered.
not consider this fact. Number
Why
one.
do you say PW2, evidence of PW2 has not been considered?
Yes. Now,
Yes, evidence of PW2 has been considered.
in my understanding, if you
Which
will
bag number 16?
para page 8.
Yes. Page 7, PW2.
Yes. So PW2 Manoj Kumar has also deposed. So he is not a creditworthy witness, and court has.
You forget about it.
The
There are
reason
other
has to be-
evidences on record.
He
He is just one of the oral witnesses.
no, he is a master witness for the purpose of plaintiff for the reason that he has set up two cases for the plaintiff. Now, if the trial court says that I will not believe on his evidence for the reason that his witness is not creditworthy. The appellate court has not said anything about his creditworthiness. Appellate court has referred to his witness and relied upon it. In my submission, appellate court ought to have dealt with it is that how his evidence is creditworthy for the purpose. Because he has made a clear-cut complaint which he admits in his cross-examination that yes, I have made a complaint. Then he sets up a different story. So his evidence could not have been considered. Now Dinanath Singh has given a family tree.
Why was Dinanath Singh not examined?
He plaintiff, it was a plaintiff, he is belonging to plaintiff's family. So, and he comes then later on he comes with an exhibit, one notarized document, so court says it is not under section 3 admissible. Now, appellate court doesn't say anything that how Dinanath's that subsequent affidavit can be looked into under section 3 of the evidence. It simply says that yes, 5 I will look into. He has said, and then oral evidence is trying to dispel that all that what has come. Cross-examination, in fact, establishes the appellate's case evaluation. And now, during the pendency,
This cross-examination, which is underlined one. This one, internal page 10, para number 10 of the trial court chart.
yes, that is what I will. So this aspect ought to have been dealt with. Now this aspect has been left out, and completely the document has been based for finding, and that document, in my submission, since Biswanath Singh died in 84, thereafter this all activity started, and this is not a document to which this appellant is a party. And this document was not even at that point of time within the framework of a public document. It is a 91 exchange deed that only refers Biswanath Basmati Devi. It does not say anything more. Basmati Devi, wife of so and so, area so and so.
Yes. The
To that
previous
extent.
name is there even in the year 1991.
So the main person died in 84. My submission is 84 he died. Thereafter this
That's like
document.
84 he dies. When did she get the employment?
No, she comes after the death of Radhe Singh.
Just a moment.
2000. After Radhe Singh dies,
Just a minute. The original employee was? What's his
Vishwanath
name?
Singh.
Vishwanath.
He died in 84.
1984 died.
Then this man Radhe Singh impersonated Vishwanath Singh and continued his tooth service and continued till 2000.
Radhe Singh impersonated
Yes.
Vishwanath.
Just one.
And he was given employment as?
It just a 1 minute clarification. One clarification. I just used the whole that Radhe Singh took job presenting himself to Vishwanath Singh in 1964.
Presenting himself as?
This Vishwanath Singh. This railway conducted that inquiry later point of time.
You just give me the date. Who was the original employee?
Vishwanath Singh.
Vishwanath. Okay, then what happened?
Then 2000 Radhe Singh died.
See, there 2000, 84, 91.
84
He,
Vishwanath Singh
when
died.
was Vishwanath Singh was employed?
64.
1964.
Yes, 23/8/1964.
Okay, he died when?
It has come in the judgment mallet that he dies in sometime in 1980.
1984. Then what happened?
Page number 5 of the.
Then what happened?
Then this Radhe Singh comes into picture and he takes the employment probably.
Employment saying that he is Vishwanath Singh.
Yes, that is what it.
No, how is it possible? A person who is working, he expires, then how somebody else will come and take the employment as in his name? How will he take the employment?
That is the inquiry based on which we have rejected his claim because he dies in 2000. Then this lady.
Radhe Singh claimed employment as what? As the son of Vishwanath Singh, was he employed on compassionate ground? What was the reason for his employment? कुछ नहीं पता. चेंबर में पीपी का टाइम नहीं मिलता. You are not aware about the facts of the case. चार डेट आपको नहीं पता है.
नहीं डेट तो पूरा हम
बताइए ना डेट का.
पर ये हमारे पास रिकॉर्ड पूरा नहीं है. I should confess that I am not having that record. So
when you are not
one day
having that
indulgence.
record, no indulgence.
So that is my point that this lady who has come and there is a categorical finding that these are two different persons. And she is wife of Radhe Singh.
Just a moment. Essentially, the first appellate court has arrived at a finding after scrutinizing the evidences, right? You just tell me what is the perversity in the
Perversity is
that PW2's evidence has
the
not been
plaintiff
proper.
herself has admitted. The plaintiff herself has admitted that there are 4 brothers, including Radhe Singh and Vishwanath
No,
Singh.
plaintiff has admitted that this Dinanath Singh had filed an affidavit. She has not admitted that actually this affidavit was correct. She simply admitted that Dinanath Singh had filed an affidavit. That is her admission.
In course of a process, he
Yes.
admitted in para 31 that on 2/10/2000, one Dinanath Singh submitted a family list of
Yes.
Babulal Singh.
That's right.
And then no document from the native village, no voter
That
list.
is-
So that is because those are material document plaintiff onus is from.
What were you doing when you were giving employment?
No.
You also conduct an inquiry,
No.
isn't it?
In subsequent, that is the case we did. That when the lady came, wife of Radhe Singh, we conducted entire inquiry. That is the report. Welfare inspector went. That is PW2 also admits that his welfare inspector had come.
You just tell me
Yes.
that Vishwanath Singh died in 1964. They was employed in 1964. He died in 1984. After that, what happened?
In trial court internal page 5, para 5. Internal page 5, I just.
आप इंटरनल पेज मत बताइए, आप सीधा फैक्ट बताइए.
Yes, fact वही para 5. Para 4, para 4, I'm sorry. Para 4, the defendant filed written
Page
statement.
number.
Page number, internal page 4 of the trial court judgment. Running page 21.
Yes.
The defendant filed a written statement jointly on 7/4/2006, pleading therein the suit is not maintainable either in law and fact against the defendant, and pleaded suit does not disclose any cause of action, partly communication and partly purpose of legal slaughter and persons. It is further pleaded that defendant number 1, Ministry of Railway, Raju so and so, was wrongly pleaded as who is neither necessary nor a necessary party in this case. It is further pleaded that instant suit is devoid of merit, full of laches and misrepresentation. The defendant had denied the payment of retirement benefit to the plaintiff strictly in according with the rule, as this is the case of the impersonation. The defendant countered the pleading of the plaintiff, submitting that after the appointment was given by the authority concerned to late Vishwanath Prasad Singh as Peter Khalasi in his case so and so, but in place of his elder brother late Radha Prasad Singh joined the service at home with effect from 23/8/60, impersonating Vishwanath Prasad Singh, and on verification LTI affixed on the service report of late Vishwanath Prasad Singh and LTI affixed on Panchanama. The senior fingerprint examiner of Railway Dhanbad Division opined that Radha Prasad Singh rendered his service in place of Vishwanath Prasad Singh from 23/8/64 to 26/7/2000 till date. Hence, the claim of the plaintiff for post-retirement benefit of deceased employee was denied. It is further admitted that plaintiff might
So therefore, the initial appointment, there was an impersonation in the year 1964,
I agree.
right? And there is an alias name in the year 1991. By that time, there was no cause of action. By that time, there was no cause of action. You cannot say that it is something which has come up suddenly. By that time, there was no cause of action to for him to say that there is an alias name. There was no cause of action.
Look, the impersonation.
It is not a case in the year 1994 he died, 1984 he died and somebody else came. Your case of impersonation is right from 1964.
64.
Yes.
So and what is my case of impersonation? But in place of his elder brother late Radha Prasad Singh joined.
Initial joining was दो भाई में से एक दूसरा भाई ज्वाइन कर
हाँ, एक के जगह दूसरे join कर दिए।
64 से लेकर 2000 तक काम किया।
ये और वो इसलिए कि वो दूसरे भाई के जगह ज्वाइन करने के कारण he was conscious कि हम दूसरे का नौकरी लेके चल रहे हैं। And विश्वनाथ died in 1984, 91 में इन्होंने एलियस कर दिया। यदि उसके 84 से पहले एलियस करते तो एक बात समझ में आती।
The person who worked,
yes,
he died when?
2000.
2000.
Yes.
Now you are denying the post-retirement benefits
yes.
to his widow by saying that his initial appointment in the year 1960. Fair enough.
No,
Let us see how fair you can be.
No, but
But
this too
it is an admitted fact that the same person had worked from 1964
yes,
to 2000.
Absolutely, that is the fact that is transparent from the report. But that person had impersonated. That is our case, Vishwanath Singh.
From where do you get this?
This is the finger LTI.
To what extent can you go to deny post-retirement benefits to a lady? And 1961 document is more than clinching. That is enough.
91.
91 document.
So that document came into existence only after Vishwanath Singh died.
So what?
And he was occupying the space of Vishwanath Singh. So once Vishwanath Singh dies, then he makes out a document for the purpose of his appointment.
Whose appointment? There is
For the
no
purpose of
further
benefit.
appointment.
For the purpose of benefit.
There is only one.
You
See,
that was just
this lady, his alias name in the year 90, in the deed of
91.
exchange, 1991,
Yes.
was executed by whom? This document was executed by whom?
Between two persons in the family.
Which two persons?
Yes.
Which two persons?
Yes, that is it. I am just giving that. Just one thing. It's exchange deed, land exchange deed. Yes, it is between exchange deed of land between Srimati Kunti Devi and Mosammat Razia Amatya Devi and Basmati Devi. That is at para 22 of the appellate court.
Para number 22.
Yes, Exhibit 7 was dealt with. It will be out of this Exhibit 7, most important document, which is a registered exchange deed of land between Srimati Kunti Devi and Musammat Razia, Amatya Devi and Basmati Devi, wife of Radha Prasad Singh, alias Vishwanath Prasad Singh.
Now I don't get it. Deed of exchange, on one hand Srimati Kunti Devi,
Yes.
and on the other hand it is Musammat Razia.
Razia.
And who is Amita Devi and Basmati?
Amatya Devi and Basmati. Basmati is the printing.
Who are they? मतलब exchange किसके पीछे है? वो चार आदमी का नाम?
Three will be on one side.
Yes.
Kunti Devi and Musammat Razia will be one side, and Amatya Devi and Basmati Devi will be on the same side.
इतना किसी जान के पीछे मत पड़ो।
जहां के पीछे हम लोग को तो वी आर डिस्ट्रेसिंग आवर ऑब्लिगेशंस। जहां के पीछे क्यों पड़ेंगे हम?
जान के पीछे पड़े मतलब रेलवे स्टेशन के पीछे पड़े। इस 64 से जो बंदा काम कर गया, there was no cause of action and in the 1991 there was no cause of action, but nobody could have imagined कि ऐसा हो
जाए। only one line that 84 में वो मर गए, उसके बाद ये एक डॉक्यूमेंट एग्जिस्टेंस में आया, इसका पार्टी कौन? Just take
84 में वो मर गए। विश्वनाथ सिंह मर गए 84 में, कहाँ आया है? Where is that fact?
That is a fact. That is
and
trial court judgment.
Trial court judgment. Who has deposed that he died in 1984? And what is the proof of his death?
Complaint given by PW2.
PW2 has not supported the case.
But he has accepted that I had given an affidavit.
Maybe.
He cannot move out of it. I can.
Death certificate line है उनका. ठीक है, वो झूठ बोला।
Fact admitted did not be proved. Fact admitted did not.
It is not an admitted fact.
I can use his evidence. He cannot reside from it. That is my.
Second appeal तो नहीं बनेगा।
नहीं, second appeal में केवल मेरा एक ही substantial question है कि 41, 31 आपके judgment के लाइट में क्या वो digress कर पाए हैं ट्रायल कोर्ट के judgment को? That judgment which I have placed before your leadership. Just for a moment, have a look to that. It is dealt with your leadership. Para 2. ये judgment दिए थे आप?
मेरा judgment हमको पता ही
नहीं हम लोग को कहा गया कि शास्त्र सुचिंतित पूरी देखिए। The documents has to be revisited each time. Para 2 जरा देखा जाए तो you have framed that issue and that is the issue that will fall from this. Para 2 and para 40 to 21 you have dealt in so precision. Para 21 will be most relevant paragraph for the purpose. Last one.
Yes.
Para 21. Yes. Upon perusal of the opinion passed by the appellate court, the court finds that on bare perusal of the judgment, the first appellate court has not adjudicated the appeal in accordance with the provisions of 4131. When held with the aforesaid judgment passed by Honorable Supreme Court in Patna. On the face of it, neither the point for recalculation here it was framed, nor its finding is supported by reasons, nor it is dealt with the reasons of the learned trial court while reversing the judgment and DP passed by the last line will be that the finding independent given by the trial court was not even touched by the appellate court. It went only on Exhibit 7 and PW2. That will be my submission. Yes, I cannot travel beyond that.
finding of the railways was in the inquiry report, no?
Yes.
That was exhibit. And what is the date of that report?
No, that is not exhibited. That is not.
Defendant number 4 had given a finding on 30/7/2003.
That they have challenged in this.
Yes.
And but that document they have also not produced, we have also not produced. That has not been marked as an exhibit. So far as I could gather from the judgment, it is exhibit.
So the trial court has recorded a finding that the evidence produced by the plaintiff is not sufficient to rebut the finding of the railways. Which is the finding of the railways?
This judgment.
Finding of the railways it was in the exhibit that was in the report dated 30/7/2003.
37,003 was the order that was passed. That is there at page number. It is not. That has not never marked as an exhibit.
That is not an exhibit. Then
That is
how
not.
the learned court has come to a has recorded that the finding of the railways has not been rebutted by the plaintiff.
Because that fact was not displayed that we have returned a finding and they had challenged this order.
This is the finding of the learned trial court.
Yes, yes. And
The
this-
finding of the railway has not been rebutted. Which finding of the railway has not been rebutted by
There
the
is no
plaintiff?
reading. They had challenged 37,003.
Yes.
It was there almost to get it marked exhibit because that was under challenge. They failed to bring it on record. Now we also could not bring it on record. They never said that they were not having the custody of this document because they had challenged this document before the CAT. 37, if your ladyship will come to the trial court, what was the relief they sought for? The very first paragraph is the challenge of the suit has been filed for declaration that order dated 37/2003 by defendant is legal and Vishwanath Prasad Singh and Radha Prasad Singh are the same persons. So they have challenged it. So onus was on them, burden was on them to bring this document on record. Now based on pleading of the parties, this fact was not displayed that there was a finding based on pleading, but this document was not brought on record. And defendant cannot be faulted for it because it was the plaintiff who was assailing this law. And in absence of this document on record, they cannot
By
proceed.
this document,
Yes,
the post-retirement benefit was denied.
yes.
Right?
Saying that it's a case of, if I just play this, the deed. The content of this document is reflected in the written statement of the
Okay, heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 24/6/2016 and 8/7/2016 respectively passed by the District Judge Roman 11 Dhanbad in civil appeal number 28 of 2015, whereby the first appellate court has allowed the appeal and reversed the finding, allowed the appeal and reversed the judgment and decree dated 2/3/2015 and 12/3/2015 passed by learned civil judge, Junior Division, Dhanbad in title suit number 7 of 2006. The learned first appellate court has declared that the learned counsel for the appellant has submitted that the impugned judgment passed by the learned first appellate court does not abide by the provision of Order 41, Rule 31 of secrecy and therefore a substantial question of law be framed. He has referred to the judgment passed by this court reported in 2025 SSC Online JHAR 2350 Sangram Baski versus Hawa Hemram, decided on 5th of January 2025 in SC number 28 of 2017. He has referred to paragraph number 21 of the same judgment, which is quoted as under. The learned counsel has submitted that the learned trial court had dismissed the suit by observing that the evidence of the plaintiff was not sufficient to rebut the finding of the railway in connection with impersonation. After hearing the learned counsel for the appellant, this court finds that a suit was filed seeking a declaration that order dated 37/2003, passed by defendant number 4, within bracket the senior divisional personnel officer, Eastern Central Railway, bracket close, was illegal and also a declaration that Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person, and the plaintiff was entitled for service benefit of his father. And a direction was also sought to the defendant to pay the service benefits of deceased father of the plaintiff. The suit was initially filed by the mother, namely Basmati Devi, but on account of her death, her son, Madan Lal Singh, was substituted. The case of the plaintiff was that Vishwanath Prasad Singh had joined the services under the respondent advent as on 23/8/1964, who died in harness on 26/7/2000. And the plaintiff's mother, that is Basmati Devi, received a post-retirement benefit from the defendant. Was entitled to receive the post-retirement benefit, but she did not receive the same. She filed a presentation on 4/11/2000. And ultimately she filed a case before Central Administrative Tribunal in OA number 79 of 2003 and by order dated 26/3/2003 the case was disposed of, directing the defendant to consider the representation. The claim was rejected by the order dated 30/7/2003 on the ground that the offer of appointment was given to one Vishwanath Prasad Singh, but in his place his elder brother Radhe Prasad Singh had joined the service. And as such, Radhe Prasad Singh had impersonated his brother Vishwanath Prasad Singh right from the year 1964. The basis of the finding was verification of LTI on the service record of Vishwanath Prasad Singh and LTI affixed on the Panchnama by the fingerprint expert of railways on the basis of a letter and statement given by one Dinanath Singh, another brother of the deceased Vishwanath Prasad Singh. It was pleaded that that Vishwanath Prasad Singh and Radha Singh were one and the same person, and one Manoj Kumar, who had made the complaint on 23/10/2000, alleging that he was the son of Vishwanath Prasad Singh and was entitled to receive the service benefit of Vishwanath Prasad Singh. Manoj Kumar had given another letter to defendant number 2 stating that his name was wrongly shown in the voter list as son of Vishwanath Prasad Singh. So he had filed the objection and that he is the son of Budhanath, who never worked in railway. And he admitted that Vishwanath Prasad Singh and Radhe Singh were one and the same person. And the plaintiff was the legal heir of deceased Vishwanath Prasad Singh. Manoj Kumar had also sworn an affidavit dated 6/2/2004 to that effect. The plaintiff also relied upon the PAN number issued to Vishwanath Prasad Singh and also the deed of exchange dated 22/12/1991 executed by Kanti Devi to Mosamat Razia, daughter of Paran Singh, which showed that Vishwanath Prasad Singh was the husband of the plaintiff and that he had an alias name, namely Radha Prasad Singh. Partition deed was also relied upon, where the Vishwanath Prasad Singh was shown having alias name as Radha Prasad Singh. It was also asserted that the defendant, on the other hand, filed a written statement opposing the prayer, and it was their case that offer of appointment was given to Vishwanath Prasad Singh and in his place his elder brother, namely Radha Prasad Singh, had joined him with effect from 23/8/1964 through impersonation. And the fingerprint expert of the railways opined that Radha Prasad Singh rendered his service in place of late Vishwanath Prasad Singh from 23/8/1964 to 26/7/2000 till death. And on this basis, the claim of post-retirement benefit was sought to be denied to the plaintiff. It was asserted that after inquiry, a speaking order dated 30/7/2003 was passed, rejecting the claim of the plaintiff seeking post-retirement benefit. It was also asserted that the fact came to notice only when Manoj Kumar Singh, son of late Vishwanath Prasad Singh, intimated by his application dated 23/10/2000 that his father, late Vishwanath Prasad Singh, had expired in the year 1983-84. And one Dinanath Singh, brother of late Vishwanath Prasad Singh, intimated to the office of the dependent as to the family particulars of Babulal Singh on 2/10/2000, according to which Radha Prasad Singh, Vishwanath Prasad Singh, Srinath Singh and Dinanath Singh were sons of late Babulal Singh. On this basis, it was asserted that Radha Prasad Singh had impersonated Vishwanath Prasad Singh in joining service. The learned trial court raised issues, including the issue as to whether Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. Both the parties, the plaintiff exhibited both oral and documentary evidences, and Manoj Kumar was examined as PW2, and plaintiff herself was examined as PW1. Numerous documentary evidences were exhibited. Including the affidavit of Dinanath Singh as Exhibit 5 and of Manoj Kumar Singh Exhibit 5/A. And also Exhibit 7, which is a sale deed number, which was registered sale deed number 14926 dated 25/10/1991. And also Exhibit 7/A to 7/B, which were the two voter identity card of Basmati Devi and Madanlal Singh. On the other hand, the defendants only filed a written statement and did not adduce any evidence in the course of trial. The learned trial court first took up the issue as to whether core issue as to whether whether Vishwanath Prasad Singh and Radhe Prasad Singh were one and the same person. The learned court highlighted that during cross-examination, the PW1 had admitted in para 31 that on 2/10/2001, Dinanath Singh had submitted family list of named Babulal Singh, who had 4 sons, namely Radha Singh, 2 Vishwanath Singh, 3 Dinanath Singh, and Srinath Singh. And on this basis, the court recorded that the plaintiff herself had admitted Radha Prasad Singh and Vishwanath Singh were 2 persons. The court further observed that the plaintiff did not produce any family list and Khatyan of her native place, Rohtas, Bihar, in support of her claim. While considering the exchange deed Exhibit 7, the court observed that the first name Radha Prasad Singh as Vishwa Prasad Singh, and so the inference may be drawn that the deceased employee was having the first name as Radha Prasad Singh. It was also observed that the affidavit sworn by public notary cannot be treated as evidence. While considering the evidence of PW2, on whose application the defendant authorities had conducted the inquiry, the learned trial court observed that the witness was not reliable and trustworthy, and observed that this witness had admitted the claim of the plaintiff with ulterior motive, but he admitted that the inquiry was made by the railway authorities on his application, and he did not give any documentary evidence in support of his claim. The other witnesses were considered, and ultimately the court held as follows in paragraph 11. This court finds that the learned trial court was ultimately of the view that in absence of documentary evidence of native place at Rohtas, it could not be held that the Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. And the documents furnished by the plaintiff were prepared at Komo, Dhanbad, and they were not sufficient to rebut the finding of railways and to decide the case in favor of the plaintiff. It is important to note that the railways did not adduce any evidence, and even the finding of the railways and the materials which the railways collected during during inquiry have not been placed on record. Although the written statement of the railways referred to various had referred to verification of handwriting expert of the or a verification by the handwriting expert which became one of the basis for the railways to come to a conclusion that Vishwanath Prasad Singh and Radha Prasad Singh were not one and the same person. The learned first appellate court has considered the materials on record threadbare and has also taken note of the issues which were framed by the learned trial court. In paragraph 5 of the judgment, impugned judgment, and the appellate court has dealt with the core issue involved in this case while discussing the evidences, which was as to whether Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person, and has specifically recorded in paragraph 14 as follows: quote, after hearing both sides and perusing the material on records, I am of the view that the main point for determination involved in this appeal is whether late Vishwanath Prasad Singh and Radha Prasad Singh are one and the same person in the performance. The learned first appellate court has considered the evidence of PW1, Basmati Devi, the original plaintiff, in paragraph 15 as follows, paragraph 15 quote question. And so far as the evidence of PW2 is concerned, the same have also been considered. He admitted that he was in inimical terms with Basmati Devi due to land dispute. It is not in dispute even from the side of the respondent, from the side of the defendants, that the entire inquiry triggered by virtue of application furnished by PW2, Manoj Kumar. PW2 had also stated in his application that Vishwanath Prasad Singh worked till 1983-84, but he deposed before the court that that fact was incorrect. And he also deposed that his father's name was Budinath Prasad Singh and he was not the son of Vishwanath Prasad Singh. Although in the application of complaint, he stated himself to be the son of Vishwanath Prasad Singh. The learned appellate court recorded in paragraph 20 that on the basis of oral evidence of PW1, Basanti Devi, PW2, Manoj Kumar, PW3, 4 and 5, it was clear that Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. The court specifically considered the documentary evidences placed on record, including the registered deed of exchange dated 25/10/1991, wherein Vishwanath Prasad Singh was shown as with alias name as Radha Prasad Singh. The court recorded that this deed of exchange was much earlier when the dispute arose with regard to genuineness of the name of Vishwanath Prasad Singh as Radha Prasad Singh. The court also took into consideration Exhibit 4 by V, which was the application given by Manoj Kumar, who stated that Vishwanath Prasad Singh was also known as Radha Prasad Singh. The learned first appellate court, on the basis of the evidences adduced on behalf of the plaintiff observed that the onus was upon the defendant shifted upon the defendant to prove that, to counter the evidence of the plaintiff, or to prove the basis of the finding dated 30/7/2003, passed by defendant number 4. But this onus was not discharged by the plaintiff, by the defendant, and ultimately held that on the basis of oral and documentary evidence, Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person, and observed that the learned court below has failed to properly appreciate the evidence on record and pass the improved judgment and decree which deserved to be set aside. This court finds that not only the point of determination was framed by the learned first appellate court, observing that the main point was as to whether Vishwanath Prasad Singh and Radha Prasad Singh were one and the same person. But the learned first appellate court has also recorded that the learned trial court had failed to properly appreciate the evidence on record by passing the impugned judgment. The learned first appellate court has considered every material placed on record threadbare, including the sale deed dated 25/10/1991, which showed that Vishwanath Prasad Singh with an alias name of Radha Prasad Singh. And admittedly, at that point of time, there was no dispute as to the identity of Vishwanath Prasad Singh and Radha Prasad Singh. The false complaint lodged by Manoj Kumar was also duly explained and considered by the learned first appellate court. This court finds that the learned trial court was of the view that the plaintiff was unable to rebut the finding of the railways to decide the case in favor of the plaintiff, and the learned first appellate court had considered the materials on record and has recorded that the plaintiff had duly adduced evidence and the onus shifted upon the defendant to prove their case. This court finds that the learned first appellate court has decided the case in accordance with law, and there is no violation of the mandate of Order 41, Rule 31 or CPC, and accordingly the judgment relied upon by the appellant does not take the appellant in any manner. Consequently, this appeal is hereby dismissed. 5 प्रश्न पता ही नहीं चला.